Okay, so last time we were talking about different types of assignments, Excel assignments, statutory assignment, and the important question is whether these things are really transfers or not. Is it possible to transfer a shows in action in the same way that you can transfer ownership of goods, for example? So that's what we're looking at last time. So we're going to finish off a bit on priorities, that's quite important now, and then what we'll talk about are the restrictions on assignment. Okay, but were there any questions from last week? Now you've had the chance to think about it for 7 days. No? Okay, so priorities, this is worth knowing about because it bears on this question of what's the statutory assignment and how does it relate to an Excel assignment. So if you consider, so remember we're looking at A, who's the party who's got the claim against X. So X is usually like the customer who owes some money to A, and A is the assignor. A is the person who is trying to assign the benefit of the debt. Sorry, those are the wrong pens. Let's try and find the correct pen. Somewhere over here. Yes, that's not terribly visible, is it? So we've got A, who's got the right to sue X. A's got a contractual right against X. So X owes a debt to A. So, in commercial terms, X would be the customer, A is the company that wants to try and raise some money by dealing with this debt. So imagine what happens is that A initially has an equitable assignment. They make an equitable assignment to B1, okay? Imagine that's what happens. So do that first. That's the first thing. But then later on, they make a statutory assignment of the same debt, the same right against X. They make a statutory assignment to B2, okay? And let's say B2 is in good faith. They don't know about this earlier Excel assignment in favour of B1. So B2 is in good faith. They don't know about the earlier equitable assignment to B1. Okay? But then there's a dispute between B1 and B2. Let's say that X pays the money to A, and B1 says, no, that should be my money. There's an Excel assignment to me. And B2 says, no, that should be my money. There's a statutory assignment to me. Okay? Now you can have that dispute either before the debt is paid by X or after it. But clearly there's a dispute between B1 and B2. They're both claiming in respect of the same asset, which is the right that A has to sue X. Okay? So, who should win in that situation? Who wins, do you think? B1 or B2?
Whoever gave notice to X first.
Yeah, so the rule is, good, assuming they're both in good faith, that they don't know about the other assignments, the rule is, whoever wins is the person who gives notice to X first. So if B1, after the Excel assignment, gave notice of that to X, then B1 will win, B1 will have priority. Okay? And what problem does that cause for B2 when B2 gets their statutory assignment? What's the risk for B2? exactly. Even if, for the statutory assignment, what's one of the things that B2 has to do for the statutory assignment to work? Yeah, there has to be notice in writing to X. So we know, because there's a statutory assignment, we know that B2 has given notice. But you're right, the risk for B2 is that there was an earlier Xwell assignment, and B1, the Xwell assignee, gave notice to X already. If that's happened, then B2 is stuck. B2 isn't going to get priority to this right, even though they're in good faith, even though they're paid, even though they've done everything necessary for a statutory assignment, they don't get priority. Okay? And that is actually pretty clear from the wording of section 136. And there's section 136 on the slide there. What makes it clear from the wording of section 136 that that's what happens? What shows you that a prior Xwell assignee can, in some circumstances, take priority over the statutory assignment? You've got this phrase here, subject to equities. Okay? So, section 136 is telling you what statutory assignee gets, what B2 gets, but they're getting it subject to equities. Okay? And this rule about giving, that you get priority by giving notice first, you know, that's an Xwell rule. And what case is that from? Yeah, so that's the rule in Derlin Hall, that if there's more than one assignment, the way you determine priority is by seeing who, in good faith, gave notice to X first. And the crucial thing is, that rule applies the same whether or not the second assignment is a statutory assignment or an Xwell assignment. Okay? So from the point of view of priorities, you don't really get a benefit by having, if you're B2, you don't really get a benefit by having a statutory assignment rather than an Xwell assignment. Now, the reason that's important is because you can compare it to the position where, let's say, A owns some goods. Okay, and let's say that A declares a trust for B1. Okay, A declares a trust for B1, then A transfers ownership of the goods to B2. Okay, so first of all the trust for B1, secondly the transfer to B2. Or instead of a trust, it could be, what other type of equitable right could you give somebody in goods? Yeah, it could be, or a sort of charge. Xwell mortgage is an example. I suppose more common would be a charge, like a fixed charge or a floating charge. So it could be that they've given B1 some sort of equitable charge, or mortgage if you like. Okay? So in that situation, you've got the conflict between B1 and B2 again. In this situation here, B1 got their Xwell right first, B2 got their right later on, but B2 is in good faith, they don't know about B1's right. Who wins in that situation? You've got an initial Xwell right for B1, like a right under a trust. Then you've got a transfer of the property to B2, who buys it in good faith for value and doesn't know about B1. Who wins there? Sorry?
Isn't that like overreaching? Is that overreaching?
You could call it overreaching. Not normally called overreaching. You could call it overreaching, but
Okay.
overreaching is normally when A is doing something that they've got the power to do, whereas under the trust, you might not give A the power to transfer the title, or under the charge you might be allowed to do that. But you're right, B2 would win there. And what do we call B2 there? Yeah, they're a bona fide purchaser for value of a legal right without notice. If somebody's got an equitable interest, they can be defeated by a bona fide purchaser for value of a legal interest who doesn't know about them. You come across this? Pretty important rule in trusts and everything, and property too. Okay? And that it can come up with sort of floating charges as well. I mean, if the debtor, if the company who's given the floating charge was to make an assignment to a bona fide purchaser without notice, then that, if it's a legal transfer, then B2 would win. Now, so what's the difference then between what's happening with the transfer of goods and what's happening with the statutory assignment? What's the difference between this situation and this situation? Here, if B2 is a bona fide purchaser for value without notice, B2 wins, B2 gets priority. Whereas here, if B2 gets a statutory assignment for value without notice, they don't necessarily win. It all depends on who gave notice to X first. Okay? And the point is that sometimes people think of a statutory assignment being like getting a legal right, and an equitable assignment being like getting the equitable right. So I think if you have an initial equitable assignment and a later statutory assignment, it's like somebody getting an equitable right and then somebody getting a legal right. And so then the person getting the legal right should win if they're a bona fide purchaser. But they don't. They don't. When you're looking at shows as an action, when you're looking at contractual rights, you don't apply the same rule that you apply to transfers of goods. You apply the Durl and Hall rule, which is a different one. Okay? And this is confirmed in that Compaq computer case, which is on the handout. Yeah, the Compaq computer case. Okay? So people criticise this, like Auditor criticises it, and it is inconvenient, no doubt it's inconvenient for B2 in practice. But I think this is quite important in relation to what we were looking at last week about whether or not assignments involve transfers. Okay? So why is there a different result then between this case and this case? Why is B2's position different in this case and in this case? Why do you think? Yeah, I mean, that's one way of thinking. I think you're right, it's to do with the nature of a statutory assignment. I mean, one way, the way that Tam looks at it, Chi-Ho Tam, he's saying, well, based on what they say in the Torkerton and McGee case, he says, well, really, a statutory assignment is just an equitable assignment, plus you get some extra rights to sue. So it's really just an equitable assignment plus some procedural advantages. And that actually fits with the priority rules. Whereas the more common view is to see a statutory assignment as a transfer. But then that doesn't really fit so well with the priority rules, because if it were a transfer, then it would be like the case of goods. It would be a case where B1 initially gets an equitable right, but then you transfer the thing to B2, and therefore B2 should win if they're a bona fide purchaser. So the more common view of a statutory assignment is that it's a transfer, you're just getting the legal right. And if that were true, if you're getting that as a bona fide purchaser for value without notice, you should defeat prior equitable rights, which is the point that Auditor makes. But you don't defeat the prior equitable rights. So that suggests that the statutory assignment, it might not be quite the same as a transfer. And actually, if you see a statutory assignment as really an equitable assignment plus some bonus procedural rights, then that fits better with the priority rules. But you do have to be... So that's the conceptual point. You're right on that? It's quite a tricky point, but it's quite a good one to make. You know, people make these points in the exams, they get ticks for that sort of thing. Okay? So I think conceptually that is quite a good point to make, but one of the things you have to be aware of in commercial law generally, I think in commercial law generally, there's a tension between, often, there's a tension between conceptually, the best way of looking at things, what makes most sense conceptually. There's a tension between that and the context, the question of what makes sense in the commercial context. So you've got this tension a lot of the time in commercial law between concepts and contexts. Okay? I mean, you get it in lots of other areas of law as well. So concepts, like what conceptually is the right answer according to the legal doctrine, but the context would mean what's going to be a good solution in the commercial context for commercial parties to get what they want and to have sensible results. So here, this rule in Dale and Hall, it does make some sense conceptually, but in the context it's a bit annoying because it makes life in practice very difficult for B2 because you can get your statutory assignment, but you're still vulnerable if there was an earlier equitable assignment and the equitable assignee gave notice. And what you're going to do before you get your statutory assignment, you don't really want to have to go and check with X as to whether or not X has received notice from anyone else. So that's the point that Ogister makes, that commercially it's a bit inconvenient. And you get this a lot in commercial law, in particular, the tension between the right thing conceptually and what in the context is convenient. It's like with charges, you know, before the Spectrum Plus case, it was very convenient for creditors to be able to take a charge that gave the debtor the freedom to deal with the goods, but still counted as a fixed charge. That was quite convenient for them, because then the debtor could still deal with the goods, but the creditor got all the benefits of having a fixed charge. The trouble was, conceptually, it didn't make sense, because they were trying to say, we've got a fixed charge, but it's okay for the debtor to do all this stuff with the property. And so in Spectrum Plus, the House of Lords says, well, you can't do that. Like, conceptually, for it to be a fixed charge, it has to be that the debtor doesn't have the freedom to deal with the goods in this way. Okay? So it's not really a fixed charge, it's only a floating charge, and therefore you don't get the protection that you want. But tough, because conceptually that's just what a fixed charge is, and what you've created was a floating charge. So sometimes the concepts win out, but sometimes the context sort of wins out. And that's where you see a lot of the sort of tension. Okay? And you know, it's useful for essays and stuff if you can sort of dress things up a bit and make it look like there's some overarching question to sort of set the scene a bit. It makes the essay look more interesting. Okay? Yeah?
What's the authority for a good faith purchase or defence to defeating pre-existing equitable right?
This one?
Mm-hmm.
Pilcher and Rawlins is the one that people normally give. Pilcher, like pilchard except different at the end, and Rawlins, like Rawling except different at the end. Okay? Pilcher and Rawling. But that's an example. You don't need to give authority for that. If you say the bona fide purchaser of a legal interest in goods defeats a prior actual interest, that's fine. You don't have to give authority for that. Everyone knows that. That's why when I asked it, everyone put their hand up. Everyone knows that. Okay? Be like gravity. You don't have to give authority for gravity. It's just there. Yeah?
If B2 is trying to find out if there's